Good afternoon, ma'am. Can you please state your name and NDOC number for the record?
Margaret Rudin, 70503.
My name is Commissioner Della Torre. To the right of me is Commissioner Christensen. To the left of me is Commissioner Keeler. You are being seen today for your discretionary parole hearing on case number 142448, count 2, use of a deadly weapon enhancement, for which you were sentenced to 120 months to life in custody. You have a parole eligibility date of December 15, 2019. Is that sentence structure correct, caseworker Keiko, and does she have any holds or detainers?
That is correct, ma'am, and she only has a notify from PNP.
Thank you. On the screen, ma'am, you will see your notification of rights. Is that your signature?
Yes, it is.
Since you've been properly notified of your rights and you confirm that that is your signature, we'll be able to proceed with the hearing today. And for the record, it should be noted that the safety of the victim's family, and the general public will be considered before any parole or post-judgment release decision is made. Any release is granted, the same will be considered in ordering your release conditions. Do you understand that?
Yes.
Okay, ma'am. I would like to notify you that your attorney, Mr. Travis Barrick, is here. And you also have an attorney there, correct?
Correct.
Sir, do you mind stating your name and your badge number for the record? Bar number?
My name is Greg Mullinax, and my bar number is 4704.
Thank you.
California.
That's Nevada bar number.
Oh, sorry.
So, Ms. Rudin, your attorney would like to speak before we get started, okay?
Surely.
Oh, thank you.
Please state your name and your bar number.
Good morning, Travis Barrick, bar number 9257. Hello, Margaret, you look lovely.
You can see me, I can't see you.
Well, I'm not so sure I look lovely, but you do.
Thank you. Hello.
Thank you, and it's a privilege to be able to address the commissioners this morning. I only hope I don't screw it up. May I begin? So, we all know the circumstances behind Ms. Rudin's conviction, but there's no back to the future for Ms. Rudin, right? There's no way she can go back and undo what happened, for certain. But she also can't go into the future and recreate the circumstances that led to that crime. That's just not going to happen. She's 76 years old. She is in poor health. And I can't imagine a universe where she poses a risk to the public. It's just hard to imagine. I understand my understanding is that's the board's primary concern. If I may, just a little background. Ms. Rudin wrote to me in late 2016. She had several civil rights cases going in federal court. They had been referred to the pro bono program. I corresponded with her. I was appointed a representative in those two cases in March of 17. Recruited a couple law students from Boyd. They came to work in our office, and we took Margaret's complaints, which were basically a summary of gripes and grievances that she had with the prison system, right? But they weren't really packaged in a way that were actionable. So a lot of effort. We put a lot of time into consolidating those two cases and filing an amended complaint, and then the Department of Corrections came to the table, right? And we negotiated a settlement. And just a couple things about that settlement agreement I think are important and relevant here. Our assertion is that Margaret doesn't pose a risk to the public because of the Back to the Future issue, that she has community support. She had no priors. She has some education. She has had businesses. She's capable of taking care of herself. She'll have Social Security when she gets out. But how do you know whether or not somebody is at risk? And one way to find that out is to get to know them. So I've gotten to know Margaret over the years, and there's just three things that I want to mention in the settlement agreement that I think can give you comfort to understand why I'm saying there's no risk for her to reoffend. one of the terms in the settlement agreement is that the NDOC was going to schedule a meeting between Ms. Rudin and the Associate Warden of Programs to discuss the problems with the law library in the prison. Margaret has a fully developed sense of injustice or right and wrong, which she carried with her entire time in prison. How many times, Margaret, did I ask you to mind your own business and stop sticking up for other inmates? Huh? So this was a real issue.
A few.
And the other one was the NDOC agreed to have a meeting between her and to discuss issue regarding elderly inmates. Once again, these were a lot of the issues that we dealt with in her civil rights complaint that we settled were her problems, but they were bigger than just her problems. And so Margaret really did care about other people and how other people were being treated in the prison, and I think that's evidence that she does have a sense of fully developed sense of right and wrong, maybe to her own detriment at some level. The last thing I want to mention as part of that settlement agreement was that the Department of Corrections agreed in writing that they would not oppose her parole, her application, her granting of parole, right, absent any major disciplinary charges, and as far as we know, there haven't been any. So I think that's the kind of thing that I just wanted to bring to the front. I'm somebody that's got to know Miss Rudin and in a way that few other people have. I think the elements of this settlement agreement give you comfort that she is not crazy, that she does care about other people and care about right and wrong. So just to sum up, unless there's any questions, I'd just like to say she has family support that's flexible. Whatever parole plan ultimately gets approved, whether it's a compact transfer or here, she has family and relatives that are willing to live with her, either support her there or here in Nevada. So I hope I've given you something to which you can agree with me that she poses no risk to the public and that she's done her 20 years. Any questions for me, Commissioners?
Well, we do have a question. In reviewing her parole hearing report, Ms. Rudin states that she basically sustains that she's not guilty and that there is a case in the Ninth Circuit Court of Appeals. Is this case still being appealed?
Only secondarily would I know, but yes, I believe that appeal is in federal court right now. Whether or not she's guilty and the whole thing about her conviction, I have zero way to know one way or the other.
Is this where the other attorney comes into play?
I would
Yes.
assume so.
Okay.
Yes.
Okay.
Anything else for me, Commissioner? I wish there was. I wish you had some stinging question that made me squirm. Okay, thank you.
Okay, so I will ask the attorney now at the institution, is her case still in appeal?
It is, Your Honor. It's pending before Judge Boulware in the Federal District Court here in Las Vegas.
Okay, well, thank you for that information. Okay,
Welcome.
so given that it's still in appeal and this hearing is recorded, so everything that we say here it's a record, we're not going to go into the details of the crime, okay?
Okay.
Okay. So I will ask the inmate at this time, will you like to make an opening statement for the board's consideration before we get started?
Yes, I would. Can I see that?
Did you want?
I handed it.
Ma'am, one moment before you get started, your attorney wanted to break in and say something.
I apologize. I thought I was being spontaneous and funny. I was going to say, Margaret, why don't you just answer the questions?
Well, they don't allow me to because last time I was here, when I rolled over on this sentence, they told me that it can be subpoenaed and they don't want me to answer any questions on an open case. And I don't think I've even told you because months
Margaret,
ago.
hang on. Margaret, whoa, time out. I don't know that that's where they're going. But I'll withdraw. I was going to object to you make an opening statement because I don't trust you because you're smart. but you're the captain of your own ship, so I withdraw my objection.
Let me just add something, and this is a common practice that happens. When cases are on appeal, for whatever reason, there's a possibility that you could incriminate yourself saying things that are a matter of public record. So, you know, when we ask you to make an opening statement, and if you make some statement that could adversely affect your federal case, we want to be clear with that. So, you know,
Okay, I appreciate.
As Commissioner Della Torre indicated, is that we're going to hesitate to ask you any questions regarding specifically the crime and the nature of the crime, because again, it's all encompassing and does in fact probably would affect your federal your federal case right now. So we're kind of at a weird dilemma here. You understand?
May I add something?
Sure, absolutely.
Could I address the board just for purposes of her appellate issues, because I think they're significant, and we don't have to get into the underlying facts of the case, but to understand what Margaret's been going through since right after her trial, if y'all want to hear it.
It's up to you. If she wants to disclose that information, that's up to her.
Do you want me to?
Yeah.
Okay.
Yeah.
Okay, well, I'll just briefly tell you kind of what's been going on and how I got involved in the case. I'm an attorney in Fresno, California. I started my legal career in Nevada back in 1991 when I went to work for Frankie Sue Del Papa in the AG's office. But I haven't been here in many, many years. But I just happened to see a Ninth Circuit opinion that came out, and I believe it was in September of 2014, and it was about Margaret Rudin's case. And I didn't know Margaret Rudin from the Man on the Moon, didn't know anything about her case or anything. I just was probably procrastinating, so I printed up the case and started reading it, and I was shocked. It was one of the most shocking opinions I've ever seen ever come out of a court of appeals. And what was so shocking was all the malpractice, the malfeasance, and everything that went on with the attorneys, and in some cases judges in her case before this period. One of the contentions on appeal is ineffective assistance of her trial counsel. This case was broadcast on Court TV and was broadcast locally live. Everyone who watched it was upset over the way her attorneys performed, but what made it even worse, on her appeal, she was appointed a local Las Vegas attorney to represent her on her appeal, and he abandoned her. And that's not my term, that's what the Ninth Circuit Court of Appeals said. He waited for over a year to file I don't think he ever filed anything on your behalf.
2 years.
Even though Margaret herself tried to file it, the judge wouldn't accept the filing. And so after that, she was appointed another attorney who was told that he had to file an amended petition. Well, actually, no petition had ever been filed. So when he went down to file the petition, he realized nothing had been filed, and so he told the judge that, which was what he should have done under the rules of professional conduct. But eventually they had a hearing before Judge Lohr, and I hope I'm pronouncing her name correctly. It's Loehrer, I believe. She actually took testimony from other attorneys who were involved in the case. She looked over the whole record, and she granted Margaret a new trial. Then, for the first time ever, the state appeals it to the Nevada Supreme Court, saying that her petition was late. But at the time that happened, the state thought the petition had been filed on time. The judge thought the petition had been filed on time. Everyone who was a professional in the legal profession thought everything had been done properly, and it wasn't. Instead, what we have is Margaret has been denied a right to new trial ever since that time. So then her attorney at that point goes to federal court and files a case there. Well, the court there said, well, too late, you didn't file your stuff on time. And so you're out. So then she appealed it to the Ninth Circuit, and that was the opinion I read. And when I saw these facts, I just couldn't believe, as a member of the bar, appeals are supposed to correct problems in the trial court level. But none of this was caused by Margaret. It was caused by lawyers, and in some cases judges. And so finally, the Ninth Circuit decided to rescind their decision, and now we're back to, they changed their mind, which very rarely happens, and they're allowing her case to proceed, and now we're in federal court, and we're hoping to get a decision before the end of the year. But my point is that her case is not frivolous. She was ordered a new trial by a district judge here in Las Vegas back in 2007, I believe. And that's why I got involved in the case. I've spent hundreds, if not thousands of hours on this case, thousands of dollars on this case, because it offends me so much as a member of the bar that this could happen to somebody. it's just, I could go on for days and I'll stop, but I just wanted to give y'all a little perspective about where we are at her point in her appeal.
Well, thank you for the insight. We really appreciate that. As I mentioned previously, we will not be asking her any questions in regards to this crime, but I just would like to let her know that the board does take the information on the pre-sentencing report as facts. So I just need to let you all know that, okay?
Okay.
Okay.
There were a lot of mistakes in the pre-sentencing report that I pointed out to my attorney in court. He said that happens all the time, and he let it go. He didn't even point them out or object to it on the day that the sentencing was done. I would like that to be considered, that I could point out those mistakes.
We can appreciate what you're saying, and we hear what you're saying. However, the parole board doesn't have the ability to negotiate, the document that we received, after the court, used it. The time, as you know, is, it's sentencing to get that corrected with the court. So, it's unfortunate that may well have happened, but we don't have the authority nor the right to decide what is accurate or not accurate in the pre-sentence investigation report. That belongs to the court. But we do appreciate, and hear your concern, though.
Okay, the only other thing, may I speak?
Yes, ma'am.
Oh, the only other thing I wanted to point out was the 9th of last month, we got the final disposition from Judge Boulware at the U.S. District Court level, and he said that he wanted some of the mistakes corrected from the AG's office, and that he wanted one thing from Mr. Mullinex, and then he was going to be making a decision within the 4-month or 5-month period of time that it takes for that to happen. I had put into my parole plan that I wanted an interstate compact to go to Illinois because of my daughter. I would like to request that not be considered until such time as Judge Boulware makes his decision. I would like to be here and available for questioning, for answers, for whatever they might need me for until Judge Boulware closes out that case.
Okay. And we'll talk a little bit about your parole plan towards the end of your hearing, okay?
Okay. Oh, I thought that was all. I'm sorry.
Well, we're going to discuss that. Okay. So, ma'am, I will now go over your parole risk assessment, which are factors being considered, so please follow along. During your first arrest, you were 24 years of age or older. You were actually 56 years of age. You have no prior parole or probation revocation. You were employed less than full-time during your instant offense. You have no history of property convictions. There's no history of drug or alcohol abuse. You are a female. You have no prior felony convictions, and you're currently 76 years of age. Is that correct?
Correct.
Caseworker Cagle, she is not a validated gang member. She has done multiple programming that we are giving her credit for today. She has one or more offenses in custody. She actually has 3 minor offenses in the last year, and her custody level is medium. Is that correct?
Yes, ma'am.
Okay. Ma'am, that gives you a total risk score of a -1, which is a low risk to reoffend if granted parole today. I will now go over your aggravating and your mitigating factors. Those factors are also being considered. Your aggravating factor is the impact caused on the victim and or the community. According to the records, you shot the victim and killed your husband, who's a victim. The mitigating factors is that we have community and family support. You claim that you have family, as you mentioned, in Illinois. You have friends that are in your support. You have participated in programs that address your incarceration, and you have no prior criminal convictions. Is that correct?
That's correct.
Okay, ma'am. So at this point, I would just like to ask you, in regards to your release plan, you mentioned that you want to hold off on that. So if you're granted parole, are you willing to be paroled to Nevada? Be released to Nevada?
Yes,
Do you have support?
Yes.
Do you have support here in Nevada?
yes.
And how will you be supporting yourself economically?
Primarily with Social Security, but I also plan to work part-time, and I want to go to UNLV and continue my education until I get the BA that I don't need that many credits yet to achieve.
Okay. Do you want to talk a little bit about the classes have you taken while in custody? What have you learned?
Primarily, the number one thing that I've learned is we have so many opportunities here for girls to educate themselves, to learn how to be more self-developed, self-confident. I think that a lot of the things that they teach us are how to work from within to change ourselves. I've worked with a lot of the young girls, helping them to do their homework, to tutor them, to even help teach the Spanish-speaking girls to speak English, because that's what I did for a while when I was in Mexico. And I think that we have opportunities that are very, very good for us here if people will just take advantage of them. And education.
I will now ask the panel if they have any questions. No questions. Okay, ma'am, we don't have any other further questions. We went over quite a bit of information fairly quickly and over your plan. Is there anything that we have not covered that you think it's important for the board to know that would allow us to see you in a better light?
No, but I have a very, very strong support system in here too. And my daughter was planning on being here, but since she couldn't be because of the ear infection, I'm not sure if the executive secretary received them or not up in Carson City. They were sent to her. I don't know if you have any information there that's been forthcoming yet or not, but reference the letters and even letters from the people in here.
I don't have those letters. They probably received them up north, but they will make their ways to us, into your file.
Okay.
Okay?
Good.
Okay, ma'am.
Thank you.
So this will conclude your hearing. It does take... Do any of the attorneys want to mention anything before we conclude?
Yes, I wanted to, thank you. I wanted to make an attempt at levity and ask Margaret if she's willing to stay in the joint to be a proper mentor to all the young ladies in there. I doubt NDOC wants to keep you. That was a joke.
No, thank you. I would not even, I would not even consider staying. They'll
Okay.
have to find a new mentor.
Sir, do you want to
Okay.
make any last statements before we conclude her hearing?
Yeah, I would just like to add about, and I appreciate y'all giving me the opportunity to speak today, but I would just like to add that she does have support that I know of in Las Vegas. One of them, for example, is a former juror who was on her trial, who's been supporting her ever since the day after the verdict, I guess. And and I'm willing to help too. Although I'm in Fresno, I've been over here a lot of times working on her case, and I'm willing to do whatever to help her out if she gets released also. But I do know that she has people in the community that are supportive of her, because they've contacted me once they found out I was representing her.
Well, thank you, sir.
So, and thank you.
So this will conclude your hearing, ma'am. It does take 4 out of the 7 commissioners to grant or deny you parole. Once the board has made a decision, you'll be notified in writing within 2 to 3 weeks in a form of an order. Good luck to you, ma'am. Off record.
Thank you so much to all of you.
You're welcome.
Thank you.
Margaret.